आप देख रहे हैं रोशन पाकिस्तान न्यूज।
Vienna Convention. During the discussions of the International Law Commission on the topic of consular intercourse and immunities, there was no suggestion that Article 36 would not apply to certain categories of persons, such as those suspected of espionage. Draft Article 30A, which served as a basis for Article 36 of the Convention, was discussed by the Commission in 1960. It provided in the relevant part, and I quote, that the local authorities shall inform the consul of the sending state without delay when any national of that state is detained in custody within his district. Among the issues discussed in relation to this provision was the question whether and to what extent it was conceivable for consular notification to be made without delay in countries which had a system of detention incommunicado, whereby the person might be held isolated from the outside world for a certain period beginning at the beginning of a criminal investigation. With regard to cases of espionage, the chairman of the Commission remarked that, and I quote, a statement of a general principle of law could not possibly cover all conceivable cases. If the Commission went into the question of whether cases of espionage should be made an exception, the whole principle of consular protection and communication with nationalists would have to be reopened. End of quote. The court notes that the Commission did not go into the question of espionage at its subsequent meetings, and that the principle of consular protection and communication with nationalists was not reopened. The court further noticed that cases of espionage were also mentioned in the context of the Commission's on the possible inclusion of a reference to security zones in the proposed provision. However, there was no suggestion of consular access not being granted in cases of espionage because of national security concerns. During its 1961 session, the Commission decided to change the words without delay to without undue delay. The court observes that this decision had no implication for the scope of draft Article 36. The Commission's commentary to draft Article 36, paragraph 1b, merely states that, and I quote, the expression without undue delay used in paragraph 1b allows for cases where it is necessary to hold a person incommunicado for a certain period for the purposes of the criminal investigation. End of quote. During the United Nations Conference on Consular Relations held in Vienna from 4 March to 22 April 1963, the question of espionage was raised in relation to the words without undue delay in draft Article 36. The chairman invited Mr. Zurek, the former special rapporteur of the International Law Commission on this topic, to explain why the International Law Commission had included the words without undue delay in its draft. The explanation given by Mr. Zurek suggests that while the charge of espionage was thought to be relevant in determining the appropriate period of time within which notification to to the sending state should be made by the receiving state, cases of espionage were not excluded from the scope of the Vienna Convention. The court further noticed that in the course of the discussion on proposed amendments to draft Article 36, including a proposal by the United Kingdom to delete the word undue from the phrase without undue delay, which was eventually adopted, it was not suggested that certain categories of persons, such as those suspected of espionage, were to be excluded from the protection of the Convention. The travaux préparatoires thus confirm the interpretation that Article 36 does not exclude from its scope certain categories of persons, such as those suspected of espionage. Turning now to Pakistan's second argument regarding the existence of an alleged espionage exception under customary international law, the court noticed that the preamble of the Vienna Convention states that the rules of customary international law continue to govern matters not expressly regulated by the provisions of the present Convention. Article 36 of the Convention expressly regulates the question of consular access to and communication with nationals of the sending state and makes no exception with regard to cases of espionage. The court recalls that India and Pakistan have been parties to the Vienna Convention since 1977 and 1969 respectively, and that neither party attached any reservation or declaration to the provisions of the Convention. The court therefore considers that Article 36 of the Convention and not customary international law governs the matter at hand in the relations between the parties. Having reached this conclusion, the court does not find it necessary to determine whether, when the Vienna Convention was adopted in 1963, there existed the rule of customary international law that Pakistan advances. The court will now turn to Pakistan's third contention that the 2008 agreement on consular access between India and Pakistan governs consular access in the present case. The court recalls that point 6 of the 2000 agreement provides that, and I quote, "In case of arrest, detention, or sentence made on political or security grounds, each side may examine the case on its merits," end of quote. It also recalls that in the preamble of the agreement, the parties declared that they were, and I quote, "desirous of furthering the objective of humane treatment of nationals of either country arrested, detained, or imprisoned in the other country," end of quote. The court is of the view that point 6 of the agreement cannot be read as denying consular access in the case of an arrest, detention, or sentence made on political or security grounds. Given the importance of the rights concerned in guaranteeing the humane treatment of nationals of either country, arrested, detained, or imprisoned in the other country, if the parties had intended to restrict in some way the rights guaranteed by Article 36, one would expect such an intention to be unequivocally reflected in the provisions of the agreement. That's not the case here. Moreover, as already noted, with reference to the alleged exception of espionage in the Vienna Convention, any derogation from Article 36 of the Vienna Convention for political or security grounds may render the right related to consular access meaningless, as it would give the receiving state the possibility of denying such access. Account should also be taken of Article 73, paragraph 2 of the Vienna Convention for the purpose of interpreting the 2008 agreement. This paragraph provides, and I quote, that nothing in the present convention shall preclude states from concluding international agreements, confirming or supplementing or extending or amplifying the provisions thereof. End of quote. The language of this paragraph indicates that it refers to subsequent agreements to be concluded by parties to the Vienna Convention. The Court noticed that the Vienna Convention was drafted with a view to establishing, to the extent possible, uniform standards for consular relations. The ordinary meaning of Article 73, paragraph 2, suggests that it is consistent with the Vienna Convention to conclude only subsequent agreements which confirm, supplement, extend, or amplify the provisions of that instrument, such as agreements which regulate matters not covered by the Convention. The parties have negotiated the 2008 agreement in full awareness of Article 73, paragraph 2 of the Vienna Convention. Having examined that agreement, and in light of the conditions set out in Article 73, paragraph 2, the Court is of the view that the 2008 agreement is a subsequent agreement